Hi, I'm David Tarras, partner at the Rossen Law Firm and head of our federal criminal defense practice. I'm here today to talk to you about the federal sentencing structure, the different ways it works, and how it is so important that you have an experienced federal criminal defense attorney that we have at the Rossen Law Firm to navigate this highly complex process for you. One of the sentencing factors that a judge must consider are the federal sentencing guidelines. And in practice, the federal sentencing guidelines are arguably the most important consideration for a federal sentencing judge. When we're ultimately in front of the judge at this sentencing hearing, this mini trial about what is an appropriate sentence for you as the client to consider. So the federal sentencing guidelines is a 608-page document. It includes a very, very complex set of sentencing schemes and structures and what ultimately amounts to a calculation. It is formulaic. Ultimately, under the guidelines, breaking it down as simple as possible, each different federal offense under the guidelines has a base level attached to it, a certain number of points. Then there are adjustments. There can be adjustments that are made upwards, specific numbers of points that can be added to your starting score or your starting points that get you into a higher level, a higher number of points. There can be adjustments that can be reduced, such as somebody who substantially cooperates with law enforcement or somebody who accepts responsibility. Most of the adjustments, most of them are geared towards increasing the potential sentencing range under the guidelines. When I say sentencing range under the guidelines, what this all looks like at the end of the day, once adjustments are taken into consideration, once the offense level, the different types of charges that you may be facing or have pled to at this point, what we ultimately end up with is something called the matrix, The federal sentencing guideline matrix. This is a chart. It has an x-axis and a y-axis. On one side is total offense level. That's after all these calculations, after all of these very intricate adjustments, after your attorney, myself, negotiating which adjustments might apply, which might not. A very important factor in a monetary case, in a white-collar case, or a financial crime case is the loss amount. Loss amount in and of itself has nearly 100 pages in the guideline, just talking about how loss amount is calculated. Depending on the loss amount, for example, if it's between $45,000 and $95,000, there are different levels that add different number of points to your ultimate score. So after all of this is calculated, we end up with a place on the sentencing matrix table, And depending on where that falls in this x-axis and y-axis, you're going to end up with a range of sentences. There's a minimum sentence and a maximum within this range. So on one side of the sentencing table is the offense level. On the other side is criminal history category. So two different calculations that are going on here, two different things that experienced federal criminal defense attorney can negotiate. Even though negotiations are much, much different and much more uncommon in the federal system, there are things that can be included under different structures, different federal sentencing schemes in order to limit where you may ultimately end up on that sentencing table. For example, if you are a total offense level of 17 and have a criminal history category of 3, then you end up in a guideline range of 30 to 37 months in prison. Now, not only is this table just about the range, the total number of months that are advisory for a judge to consider on the low end or the high end of what an appropriate sentence is, but there's also different zones within that range, which you'll see on the chart. The zones are very important. Zone A, there's no need for any sort of incarceration. A judge has freedom to give you probation for a case. In a Zone B, the judge has to give you some form of confinement. It does not have to be incarceration in the traditional sense within the Bureau of Prisons, but it can be a split sentence of some sort of home confinement, community control, probation, some combination. Of confinement. Then, per the sentencing guidelines, you have to serve some portion of your sentence incarcerated. There has to be a split sentence. Now, you get to the final zone, Zone D, where the guidelines advise the judge that any sort of split sentence or any sentence other than incarceration in the Bureau of Prisons is not appropriate. Calculating criminal history category is a bit simpler than calculating the total offense level on the guidelines. However, you still need an attorney who understands how the criminal history category calculation works, what number of points are assigned to previous offenses that you may have committed on your record, and criminal history category can be negotiated. It is one of the few things that can be negotiated with the prosecutor during the plea stage, as opposed to the sentencing stage where, absent something called a joint recommendation, which is where both parties recommend to the court to impose a certain sentence or consider an appropriate guideline range, but ultimately these are just recommendations. It is all up to the judge, and our job is to make sure through negotiation, through motions, through litigation, that you ultimately end up in the most favorable range in this sentencing table possible, because this is going to be the first place that the judge looks when fashioning your sentence. Now, I ask you to remember, the federal sentencing guidelines under United States v. Booker are just advisory. A judge under the sentencing code, that other structure that we had talked about, does ultimately, under the 7-3-5-5-3 factors, have the discretion to disregard the guidelines if the judge feels that the guidelines do not adequately and appropriately justify what your sentence should be, whether it's lower or higher. Our goal, of course, is to get it lower. And this is why you need an experienced federal criminal defense attorney. You need an attorney like us at the Rossen Law Firm who knows how these different sentencing structures play out in the courtroom. Not just what reads on the paper, okay? Not just what reads on the table, but also how the different prosecutors treat the guidelines versus the code, how different judges treat the guidelines versus the code, or how they just treat the guidelines in general, knowing which enhancements can be applied, which can't, which prosecutors like certain enhancements, which prosecutors are more willing to not consider certain enhancements. If you don't have a federal criminal defense attorney who can explain the guidelines to you and the sentencing scheme in a way that you can appreciate and understand, you can find yourself in a very, very difficult situation, because this is not like state court where it's defense and prosecutor agree to a deal, great, judge signs off, good to go. Here, it is complex, it is difficult, and it requires an attorney and a group of attorneys, a legal team who can navigate this entire process for you, so you are confident going into that final sentencing hearing that we have done everything in our power to put you in the best position, and your family and your loved ones and friends in the best position to have you home and to have you have your freedom.